Good morning, everybody.
877-850-8585. That's 877-850-8585. Now here's your host, attorney Jeff Vastola.
That's me. Good morning, everybody. I'm Jeff Vastola, here to give you free legal advice. If you'd like to call into the radio show to get some free legal advice, the number is 877-850-8585. And please interrupt me throughout the entire program because I'm here for the next 30 minutes to talk, to give you free legal advice that I have planned based on my outline. But my preference is for you to call into the show with your issues, your needs, and so I can give you some free legal advice. If I can answer your question right here and right now, I certainly will. If I don't know the answer and I have to do the research, then that's exactly what I'll do. I'll do the research so that I can get back to you the following week with what I feel is an educated response to the question. And of course, it's always free. Good morning, my beautiful wife, Mandy. Typically the first one to chime in. Oh, that's right, I'm not supposed to do that anymore. Anybody watching on Facebook Live, please don't be offended if I don't say hello to you, because apparently when you're listening on the radio, it becomes very disjointed, is what I've been told. So I'm going to try to ignore the people on the screen, unless, of course, I see a question, because if you're watching by Facebook Live, same applies to you. Type in a question of your own, and if I see it pop up, and if I feel I can answer it right here and right now, then I will do that. Oftentimes I review the show after the fact, the Facebook Live show, and I see comments that people have made, or sometimes even questions that I missed, because it scrolls up and sometimes I miss it. If I happen to miss your question, then I will try to reply to you at some point over the weekend or the following week. And if I've just completely ignored you, then always the fallback is call me anytime. 833-VASTOLA, which is my last name. It's 833-827-8652 is a number that you can reach me on my cell phone. That's a toll-free number. It's forwarded to my cell phone. It's forwarded to my cell phone 24/7. And so you can always reach me on that number. Now, I will tell people when they call me on my cell phone after the show, but it's a radio show type of topic, to please call me on the show, because the show interaction is so much better. Oh, here come the puppies. The radio show interaction is so much better than me just talking for 30 minutes. So please interrupt me, as I mentioned. I do want to say this, if you know my dad, if you've heard of my dad, if you know anything about my dad at the moment, he is still in a coma. He is still fighting COVID, and so all of your prayers are certainly appreciated for my father. Today on tap, we have Florida's workers' compensation law and how it differs from a standard personal injury claim, and I'll kind of discuss what I mean by that, the different terminology. And I'm also going to be talking about, and I put it further down in my outline, just bear with me for a second because I put the statute in here. Which type of healthcare providers actually get the benefit of Florida Statute 766? Florida Statute 766 is a statute that requires medical malpractice claims to be investigated before you can file a lawsuit, and the investigation is thorough. And oftentimes it's very expensive. You have to hire experts of the same credentials of that person or persons that you're looking to sue. And those experts oftentimes charge a great deal of money to review medical records and perhaps affidavits or whatever it may be in the investigation of the claim. So if you have the protection of the statute, which requires a pre-suit investigation, that's a good thing if you're a medical provider. So I want to go through the list of all the different types of medical providers that actually get the benefits of the statute, because there are perhaps some aspects of healthcare that do not get the protection of the statute. And you may scratch your head and say, why? I don't really understand that. But legislatively, the statute it's a creature of the legislation. And so those up in Tallahassee found it important to protect these different types of providers. And so in the event anybody's interested, I'm going to be sharing that. And then, of course, my handy-dandy Florida Law Weekly update. I went through, and I don't even know if this is this week's. They kind of pile up on me, but I went through it, found some great cases to talk about in here, so I'll be discussing those if I have the time. So, getting back to the main topic of the day, and remember, if you want to call into the show, because your questions and topics are always more interesting than mine, I promise you. 877-850-8585. That's the number to call into the show. Call me anytime. But workers' compensation in Florida is meant to be the exclusive remedy if you're injured on the job. And most people understand what work comp is. They've heard the term. They have a general understanding of what it is. And I misspoke last week when I mentioned that the workers' compensation statute was section 400. Should have known better. That's the nursing home statute generally. The workers' compensation statute is 440. So as I started to do my research into this topic last night, I realized that I had mentioned the wrong statute. If you went to 400 looking for it, I apologize. But anyway, Florida Statute 440.11 is, Section 440 is Florida's workers' compensation statute, and there's a lot of different subsections within it. This is a very lengthy statute. Some statutes are very short, some are very lengthy, and then you've got everything in between, and workers' compensation is lengthy. But what I wanted to focus on today is how Florida Statute 440.11 was specifically written to inform, to set forth the law, I should say, that workers' compensation is meant to be an exclusive remedy. So if you're injured on the job, and assuming that the employer carries workers' compensation coverage, then there is no claim to be made against the employer for what we refer to as personal injury, for a standard civil personal injury claim. And there's a reason why that's important. I mentioned it last week, but I'll mention it again. In personal injury, you get to recover what are called those non-economic damages, pain and suffering, loss of enjoyment of life, those types of things. In workers' compensation, you don't get that. In workers' compensation, you get calculated amounts as to a lost wage, and you also get medical benefits paid for by the insurance company, the workers' compensation insurance company. And
Sandy from West Palm Beach.
did you say Andy?
Sandy.
Sandy. Oh, great. We've got a phone call. Sandy from West Palm Beach. Good morning, Sandy. What can I do for you? Sandy, can you hear us?
Hi, yes, I can hear you now.
Great. What's your question?
I have a landlord who is refusing to return my security deposit. It's my previous landlord.
Okay. And what communications have you had with the landlord about getting the money back?
I moved out on September 5th, and I emailed him like in October to say, are you going to send my security deposit back? And he responded by saying that he was not going to return it.
And did he give you a reason? Did he say that you destroyed my place? Did he say that I had to replace the carpets? Did he give a reason?
Well, I left the place immaculate. I have pictures, but his reason is at my I was to move out on August 31st, and I had told him on August 31st via a phone call that I was going to need a few more days, that I was just not able to get out in time, and through the phone call it was understood that he was going to charge me per day. So I was out on Saturday the 5th, so I was expecting him to withhold like 5 days, and he told me that because I was not out on the 1st that he was charging me for the whole month.
All right. Well, when you had that conversation to say I'm going to need a few more days, did he literally say, okay, but I'm going to charge you by the day?
He literally said it, but he's denying it now in email.
Okay. All right. And have you done the math to get a pro rata amount of what it would have been per day for you to stay?
I have, and for 5 days it's about, depending if he divides by 365 and multiplies by 30, or depends on, it's about $240.
And your security deposit is what?
Well, it's about $1,460.
Okay. So you're out roughly about $1,100 or so, if my math is about right. So what I would recommend that you do is first educate yourself by going to Florida Statute 83. if you haven't already. It sounds like you might have done that. Florida Statute 83 is Florida's landlord tenant statute, and it sets forth the rights and obligations of the parties. There's 3 subsections. There's residential, commercial, and then storage, but obviously you're going to look at the residential sections. I don't know the statute well enough to tell you if there's anything in there about specifically what your rights are, but I can tell you that there's going to be something in there called a holdover tenant. And what you were for 5 days is what's called a holdover tenant. Now, if you had an agreement as to what you were to pay as a holdover tenant, then that might trump what's written in the statute. But if the landlord's going to deny it because it was verbal, then look to the statute and see what the statute says about being a holdover tenant, because that's going to give you maybe a better idea of what you could get. What I would recommend you do... Go ahead, Sandy.
I did briefly skim it. It says double. So let's say it's $500. But the thing is that I think it says refuses. That the actual verbiage is refuses to, and I wasn't refusing. There was no one coming in.
Okay.
You know?
Understood. So you struck me as the kind of person that has probably already done your homework. But what I'd recommend you do is first send a letter to the landlord, giving the landlord in writing a brief amount of time to give you back what you feel is right. Obviously, you do agree that you're not entitled to the entire security deposit, but a portion of it. My recommendation would be give the landlord maybe 10 days from receipt of the letter. And I would send the letter certified mail and U.S. mail. That way you can perhaps track when he may have received it. And then if he doesn't pay back what you feel you're owed, then you can file a small claims action. And small claims is a perfect venue for your dispute. Now, there is one more aspect to the statute that I want you to look at. And there's a section in the residential statute that says a landlord cannot use... Can one of you let the dog in, please? The landlord cannot use security deposit for holdover rent unless it's specifically stated in the lease agreement or something like that. So look for that language in the statute, Sandy, to get a better idea of whether he's even allowed to maintain any of the security deposit as holdover rent, okay? You're going to compare what's written in the statute to what's compared in your lease agreement. Okay?
Okay, I didn't see anything about that in my lease agreement, but okay, I'll look again.
And what that might do is it might entitle you to the entire $1,500 or $1,400 security deposit if he didn't protect his rights to use it as rent in the lease agreement.
Well, and I don't even want that back. I feel like I rightfully owe for those 5 days, but
Right.
I just can't believe that he would,
Well,
I would have taken the whole month to move out if he had told me he wasn't gonna, he was gonna insist on charging me for the full month.
I understand.
It was.
Well, hopefully that whoever the landlord is, he or she, they'll see the light of day and give you the money that you're entitled to. But if not, you've got a real strong case in a small claims venue where you don't need a lawyer to help you. You just go in and present your own case.
Okay, because he told me he was suing or counter-suing me for legal fees and stuff. That's why I just wanted to make sure before I filed anything in small claims that I'm not likely to lose based on him being allowed to charge me for a full month. For 5 days. Because if he does prevail and then I'm out whatever his legal fees are, he's out of state, so he would have to, I'm sure the legal fees wouldn't be cheap.
Yeah. He'd likely hire a lawyer, even though it's a small claims case. Even though I said you don't need a lawyer, you can certainly have a lawyer in small claims if you want. And if your lease agreement does have
I don't feel like I need a lawyer. I'm saying.
I understand. I'm just explaining
I don't need a lawyer.
I understand that.
Try to.
Just be mindful of what's in your lease agreement. If there is a prevailing party attorney's fee agreement in there, then it will come into play. And if you want to call me back after looking at the statute and looking through your lease agreement, I'm happy to discuss these things with you in more detail. But attorney's fees provisions are something that I warn people about all the time because they can certainly come back to haunt you if you don't have a real strong case and if you don't prevail. They're meant to prevent people from filing frivolous lawsuits They're not really meant to prevent people from filing meritorious lawsuits, but you know, it is something to be concerned about.
Well, the lease agreement does explicitly say responsible for reasonable attorney fees for the party that does not prevail, but it doesn't say anything about the security deposit for holdover rent that I thought. But also, I just wanted to quickly ask for the other statute, or another part of statute 83, I guess it was. It mentions him having to have sent a letter certified, and I did not receive the letter.
That's another.
He did not request like a forwarding address.
That's what I was referring to earlier about how the lease, you know, the statute requires that the lease contains certain language in it about how the landlord is going to be able to use your security deposit, and then you are correct in pointing out that the statute also has a requisite that the landlord has to send that letter. But really all this stuff is stacking up in your favor, because if you file the lawsuit, you're going to be able to illustrate for the court how the landlord didn't do things right. And when that happens, you're entitled to your money back, or at least, as you're saying, at least a portion of it.
Right. Okay. So I guess my basic question is just that there's nothing that you know of that says that like he can charge me for a full month when I've only stayed for 5 days, and there was a verbal, which is hearsay because it's my word against his at this point.
Well, Sandra, just keep in mind, I don't have the statute memorized. I really don't remember what's in the statute word for word. The residential landlord statute is written quite simply, and that was intentional, because I think the legislature realized that most people that would be using that statute would not be a lawyer. So I would turn the table on you to say, read the statute, read the residential section only. You don't have to look at the commercial section or the storage section. But read every section and read it so that you understand it, because frankly, I just don't remember every word that's in there.
Okay, so I could learn a lot just by reading all the relevant parts, but I just felt like this is probably a standard case where the outcome would be predictable.
It sounds like you have a really strong case, but I hate to sound like a lawyer, but just understand that nobody on the planet can give you a guarantee that you're going to win a case. So,
no, I'm not looking for a guarantee. I was just, like I said, just likely, whether it would be prudent to do or but I understand what you're saying.
I think it's prudent. I think you've got, based on what you're telling me. Sorry, I don't mean to talk over you. Listen,
no, it's okay. I can't hear.
If you want to call me back, if you have any follow-up questions, then I encourage you to do that. I had another radio program a long time ago where I walked a listener through his entire small claims court over the course of about 6 months. So if you decide that you want to initiate this thing and you've got questions along the way, then feel free to call in on Saturdays and we can help you out.
Okay, that sounds great. Thank you so much. I appreciate your help.
All right, you're welcome. Good luck with it, Sandra. Hopefully the landlord just pays you and it'll go away. All right, well, thank you for the phone call, Sandra. See, that's exactly what I'm talking about. I don't know about you, but I find that much more interesting than just kind of talking about a topic that I chose on my own. And of course, Sandra, if you have any follow-up questions, please, do not hesitate to call. Sometimes I am a little bit limited with what I remember about what's in a statute or even my experience. I used to do commercial litigation and I used to do landlord-tenant type of disputes, and so I know the statute. I know where it is, and I know generally what it says, but a lot of the things, the specifics are escaping me. But very easy to read statute if anybody's interested in checking it out. The workers' compensation statute, as I mentioned before, my topic, is meant to be the exclusive remedy if you're injured on the job. And that's important because your remedies are limited compared to what you could get in a civil arena for a personal injury claim. And the section dealing with the exclusiveness of liability in a workers' compensation claim in 440.11, Florida Statute 440.11, has an exception in it. And the exception that I wanted to talk about is really very interesting because a long time ago, I don't know when they changed the statute, but a long time ago the statute was not nearly as strict. And so even if an employer had work comp, employees were finding ways to get around the statute and the exclusiveness statute to say, well, I believe that the employer did something intentional or was grossly negligent in some way, and that would open up the door to a third-party claim of personal injury. So back in the old days, the employer would not only be on the hook for work comp, which the employer pays for, because that's insurance that the employer is required to carry that is expensive sometimes, depending on what field you're in. If you're in the construction field, it's incredibly expensive. And then they were also getting hit with third-party claims for personal injury, negligence claims, which didn't have to be a third party. That could be a first-party claim. But the legislature said, no, that's enough. We're going to get rid of these, third-party claims for gross negligence or intentional conduct. And what they did was they left it in there. And it says in subsection B, when an employer commits an intentional tort that causes the injury or death of the employee, then they can be sued. But they went on to explain what an intentional tort is. You might think, well, I have a general understanding of what an intentional tort is. I know what that means. But when a term is defined within a statute, that's what you have to use. Because sometimes a term that's being defined within the statute is different than what a common or layperson's understanding, or even a lawyer's understanding of what the term means generally. You always have to use what's in the statute. And what the legislature did in the work comp statute is they defined intentional tort to be a threshold so incredibly high that unless the landlord literally intended the act, knew that it was going to cause the consequence, the injury, and everything else, and that's what the employer intended to do, and that it had happened before. Or let me read what it says. The employer engaged in conduct that the employer knew, based on prior similar accidents or in explicit warnings, specifically identifying a known danger, was virtually certain to result in injury or death to the employee, and this is the kicker, and the employee was not aware of the risk because the danger was not apparent, and the employer deliberately concealed or misrepresented the danger so as to prevent the employee from exercising informed judgment about whether to perform the work. That essentially eliminates, to a great extent, I mean, I can't think of a case where the employer would still be held for a claim of negligence or gross negligence unless, the one thing that kind of pops into my head is like if it's a claim of assault. If a supervisor punches an employee because he's frustrated and breaks his face or something, that obviously is something that would not be protected pursuant to the statute. But just about anything else in the work arena is going to be protected by the workers' compensation claim. And I have a case specifically that I recently declined because as we were going along, I was thinking to myself, wow, this might actually fall into the exclusion in the work comp statute. He was injured on the job. The employer knew that a certain piece of equipment was defective and was still insisting that the employees were using it. The warnings specifically said don't use it that way. But then I got to the section where it says, and the employee was not aware of the risk because of the danger, so. And I was like, well, how am I going to get around that? How am I going to be able to make an argument that the employer knew it was so dangerous, the employer was going around the risks and everything else, but the employee didn't know? In my mind, I couldn't get around it, so I declined the case politely. But in the event that you live in Florida, or you're working in Florida, and you're injured on the job, just understand that the workers' compensation statute is there to help you, and it oftentimes does, but it's not perfect. I don't handle work comp, but the lawyers that I know that handle work comp are oftentimes frustrated with the system, and they'll tell you that it's not a perfect system. But if you have any questions about that, you can certainly call me, 833-VASTOLA, and if you have a work comp attorney already, then call your work comp lawyer, of course, and ask any questions you want. But I'm going to move on to my next topic, and that is just a real quick recitation of all of the different types of medical care providers that get the benefit of Florida's medical malpractice statute, which is Florida Statute 766. It's a statute that's meant to protect the healthcare industry, and that plaintiffs' lawyers like myself that intend to bring a claim of medical malpractice have to dot their I's and cross their T's before you can file a lawsuit. And those I's and T's typically take on average 6 to 8 months to do a thorough investigation of a malpractice claim. We have to get all the records. We have to make sure that they're reviewed by the appropriate experts. Nowadays, getting records is a task. It takes a long time to get the records alone. Identifying experts that are willing to cooperate in this field, we call it the medical legal field, is sometimes not easy to do. But anyway, so here's the list. Starting with medical
1 minute.
doctors, Florida Statute 458. Thank you, Sharina. You've got also the DO doctors, the osteopathic doctors, which is what my father is. So again, please, prayers for my dad as he's in the ICU. You've got chiropractic, podiatry, naturopaths. Probably don't even know what that means. Florida Statute 462, if you're interested in naturopathy. Optometry, nurses, dentists, midwives, which is midwifery, if you weren't aware, Florida Statute 467. This is an interesting one. Orthotics, prosthetics, and pedorthics. And then lastly, physical therapists. Thank you for listening to my show. Thank you, Sandra, for calling in. And please have a wonderful week, a safe week. God bless. And please, prayers for my father. Thank you very much.